In most debt disputes, creditors take the first legal step. But sometimes, the debtor moves first, by filing for bankruptcy. For many foreign companies, this triggers panic. Will I lose everything? Can I still recover funds? What rights do I have? In this video, we explain what happens when a Vietnamese company files for bankruptcy, and how you can protect your position as a foreign creditor. Vietnam's bankruptcy process is governed by the law on bankruptcy. A company may file when it is considered insolvent under Vietnamese law, meaning it fails to pay a due debt for 3 months from the payment due date. Once the court accepts and opens the bankruptcy procedure, the case enters a structured track. The debtor's assets and transactions are placed under legal supervision. Creditor claims are collected and verified, and the case may move toward either a business recovery plan or bankruptcy declaration with liquidation and distribution. For creditors, the key point is simple. Rights are protected only if you act and file properly, on time. In practice, a bankruptcy case usually moves through 4 key steps. First, the court reviews and accepts the petition, then issues a decision to open the bankruptcy procedure. Next, a licensed insolvency professional, such as an asset manager or a liquidation management entity, is appointed to work under court supervision to control information, verify debts, and manage the asset process. Third, creditor claims are confirmed and a creditors' meeting is held, where key decisions are discussed, including whether a recovery plan is feasible. Finally, the case proceeds to either a court-approved recovery plan or a bankruptcy declaration leading to liquidation and distribution to creditors according to legal priority. Foreign creditors can participate in Vietnamese bankruptcy proceedings, but you must actively assert your rights. That starts with filing your claim with proper supporting documents and Vietnamese translations. You can also attend, or appoint counsel to attend, creditors' meetings where major decisions are voted on, including whether to support a recovery plan or push toward liquidation. If there are signs of unfair treatment or suspicious transactions before bankruptcy, creditors may raise objections through the legal mechanisms available in the process. The practical message is clear. If you stay silent, your position weakens, and you risk being left behind when the distribution happens. After the bankruptcy case is accepted and placed under court supervision, the debtor's assets are typically subject to preservation and control measures under the insolvency process. As a creditor, you generally cannot pursue separate, first-come, first-served seizures like normal enforcement. Recovery must be channeled through the bankruptcy procedure, which improves fairness, but can slow timelines. This is why early filings and accurate claim documentation matter. They directly affect how assets are tracked, valued, and ultimately distributed. In bankruptcy, your recovery depends on your legal status. If your claim is secured by a pledge, mortgage, or other valid security interest, the secured assets are handled under the rules applicable to secured obligations. For the remaining pool of assets, the law applies a priority order, typically starting with bankruptcy-related costs and certain employee-related entitlements, then statutory obligations to the state, and only after that, unsecured commercial creditors. The earlier you clarify your status and document your claim, the higher your practical recovery potential. In some cases, debtors file for bankruptcy to delay enforcement or avoid court rulings. Watch for red flags: sudden insolvency right after a judgment, hidden asset transfers, or new companies using old resources. LTS Law investigates these and can file motions to suspend or reclassify the bankruptcy as fraudulent under civil or even criminal law. A Taiwanese trading company lost over $900,000 to a Vietnamese distributor. Weeks before court enforcement, the debtor filed for bankruptcy. LTS Law acted fast, filing claims, challenging asset undervaluation, and exposing transfers to family-owned companies. The court froze land titles and later approved auction. After 9 months, our client recovered 72%, a rare success in bankruptcy recovery. 1. Engage a local Vietnamese law firm with insolvency experience. 2. Prepare all claim documentation and translations quickly. 3. Monitor court bulletins for case status, and 4. Attend creditor meetings, or assign power of attorney. Missed deadlines equals lost rights. Bankruptcy moves slowly, but deadlines are strict. If your Vietnamese partner files for bankruptcy, Don't assume it's over. Act fast, engage legal protection, and let LTS Law guide your recovery. We understand Vietnamese insolvency, not just the law, but the practice. Visit lts.com.vn to evaluate your claim, secure your place, and recover what can still be recovered. Because even in bankruptcy, strategy wins.